All right, ladies and gentlemen, this is the series on the little book on legal writing by Alan Dworsky. I'm not exactly sure how to pronounce his last name. Apologies on that. Anyways, we are reviewing chapter 3, style. And sometimes what you're going to see in this, you're still going to get the main points, but sometimes I'm going to go super fast through the main points when they are, simple and easy to understand. But as soon as any of the main points are a little bit nuanced or not easy to understand, not plain face easy to understand, we're going to read more about it. So let's get going. First, do not use contractions. Pretty simple. Next, don't write in the first person. Also pretty simple. Next, don't use slang unless you are quoting. And that makes sense because slang, you have to take a second step to interpret slang, and we don't want our readers to have to use energy interpreting what we say. We want to be plain-faced with what we say. Next, get serious. This is what it says. Litigation is no laughing matter. That's funny. I'm kidding. That was not funny. Anyways, a joke, even a funny one, may make the judges think you aren't serious about your case. If you treat your case lightly, chances are so will they. That's too big a risk to take for a laugh. You may think you can put a joke in an office memo because you know your boss likes your sense of humor, but you should test every word you write with the question, would I be comfortable if my client or a judge read this? Next point, avoid footnotes. Footnotes sidetrack the reader. Taking a detour to the bottom of a page and back up again wastes time and breaks a reader's concentration. Interesting. Underline for emphasis sparingly. Don't print words you want to emphasize in bold italics or all capital letters. Underline them. As the written equivalent of raising your voice, underlining can make your writing more dynamic when used sparingly. Underlining for emphasis is most justifiable to emphasize critical language in a quotation. If underlining is the equivalent of raising your voice, an exclamation point is the equivalent of shouting. Exclamation points are almost never used in legal writing. Next, use conventional typeface. I'm not going to go through that. I would Google conventional typeface because there's only so much you can do in terms of describing it verbally. Next, use right justification only if your printer spaces evenly. When text is right justified, all the lines are even on the right, like the lines in this book. Don't use right justification unless you've got a really good printer and word processing program that spaces words evenly. That makes sense because when you see spaces unevenly, it's not good. Next, don't cheap on type size, line spacing, or margins. Now this one I actually might have to disagree with a little bit. Type size, that makes sense. Let's keep everything at least in a 12-point font or something like that. But line spacing and margins, especially as we're trying to write one-page laws, we might have to be a little bit flexible with line spacing and margins. We'll see. I don't know yet. So far, I can have a traditional line spacing and margins and everything fits into one page. So we'll see what happens. Anyways, next point. Avoid putting a heading at the bottom of a page. Traditionally, lawyers have not begun a new page for each section in a memo. Most begin a new page for each introductory section in a brief, such as the questions presented and table of authorities. Some begin a new page for the statement of facts and argument in a brief. No begin a new page for each point heading. Next, indent your paragraphs. Indent the first word of each paragraph. You know what's so funny is he says indent your paragraphs, but look at that. It's not indented. I don't necessarily get that. The next paragraph's indented. So perhaps the very beginning, he doesn't indent them. I don't know. That's just kind of ironic. Anyways, this next one's pretty interesting. He says, where is it? Master the apostrophe right there. We're going to read what this says. If you're like me, you squeak through high school and college without learning to use the apostrophe properly. You may have been confused because usually possessive of a word, judges, and the plural judges sound the same. But even though they sound the same, you must indicate the possessive with an apostrophe. The basic rules are simple. Form the possessive of a singular noun by adding an apostrophe followed by an S. Form the possessive of a plural noun by adding an apostrophe after the S. Fairly simple, no new stuff there. Next, don't be a slasher. Boom, this is a funny point. He says, don't make up ugly new words using the slash. Example 14. Daly was a professor / researcher at Hamlin University. Try to make do with the few 100,000 words we already have. Example 15. Daly was a professor and researcher at Hamlin University. Next point. Avoid not un combinations. Don't say Congress was not unaware of the problem of sexual harassment when it enacted Section 1983. Say Congress was aware. Don't say not unfamiliar, say familiar. Don't make the reader do the not unhard work of converting two negatives to a positive. That's funny. Next, don't write in headnote style. Don't drop the articles a, an, and the. This is done in headnotes and telegrams, headlines, and want ads to conserve space. Buyer of Toyota sued dealer for negligence. But headnotes, besides being poor examples of English prose, aren't even good authority. You have enough room in a memo or brief to write real sentences. Put those articles back in. The buyer of a Toyota sued the dealer for negligence. You don't want your writing to sound like a poorly dubbed kung fu movie. Next, don't call someone a liar in a civil case. Lying is a sin. Criminal defendants have been accused of sinning. So, excuse me, I'm so sorry. Criminal defendants have already been accused of sinning, so accusing them of lying is relatively insignificant. But in a civil case, saying someone lied is considered uncivil. Don't do it unless the evidence is indisputable. Next, talk about death without euphemisms. Homicide, wrongful death, wills and trusts, lawyers often deal with death. Euphemisms may be justified when you're talking with someone grieving the loss of a loved one, but in a memo or brief, talk about death directly. Next, talk about contracts correctly. Watch out for commonly misused words related to contracts. If an offer isn't accepted, it's rejected rather than denied. If it's accepted, the parties enter into a contract. They don't enter a contract. You could also say they contracted with each other. They are the parties to a contract or contracting parties. In the past, they might have been called contractors, but now that word is reserved for those in the construction business. Next, don't change what you call something. Elegant variation refers to the practice of changing what you call something so as not to bore the reader. It may have some literary merit, but in legal writing, it's at best a distraction and at worst a source of confusion. Next, maintain parallelism. Now, I don't know what this means, so we're going to read about it. In a sentence, words or phrases serving similar functions should match grammatically. Oh, Sally likes swimming, walking, and running is example 17. The matching is called parallelism. It's maintained in example 17 because the three things Sally likes all end in ing. Sally likes swimming, running, and to run is bad grammar. Let's see, and then it goes through parallelism. You guys get it. You make stuff consistent with each other. Capitalize correctly is the next point. Don't capitalize every word having anything to do with law. The normal rules of capitalization apply to legal writing. The few special rules can be found mainly in Practitioner's Note P.6 in the Blue Book. Blah, 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 blah. It gets too dense here, so we're not going to go through it. But the point is to capitalize correctly. Next, don't abbreviate the names of places. The abbreviation of geographical terms given in the table blah, 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 blah are used in citations, not in text. Write out the names of countries, states, counties, and cities in full. Next, use proper style for numbers. Rule 6.2 in the Blue Book governs the use of numbers in legal writing. You should generally spell out the numbers 0 through 99. If you want to, you can also spell out round numbers like 100 and million, and you must spell out any numbers that begin with a sentence. So if you have a number that's awkward to spell out, like 1945, don't start a sentence with it. Okay, next. We're going through a lot of that. Oh my gosh. Gracefully avoid sexist language. Now this seems like a pretty good point. Grammatically, it is correct to use masculine singular pronouns he, him, and his to refer generically to persons of both sexes. But this is rightfully considered sexist language because it perpetuates the habit of thinking of the male as the model of a human being from which females deviate. And for a reader who thinks visually, the masculine pronoun will momentarily create the image of a man in the reader's mind. So we want to use she when appropriate. And you guys, that's the end of style. We did it. Wow, 10 minutes. Oh my goodness gracious. Anyways, that was the end of style. And I hope you liked the video. I hope you learned something as well. And hopefully we can crank out the rest of these videos in due time. All right, bye, bye, bye. If you're an independent and you care about being represented, even more so if you're frustrated and you feel like you're not represented, the whole point of this project, the whole point of this content is to help independents feel like they've got a voice, feel like they've got somebody fighting for them. And so that's what this content's about. If you're interested in supporting this, go to the patreon.com/MiyakeZilla Patreon page and consider supporting us for $2 a month. That's all. All right, thank you very much. Bye.